Thanks everyone for joining us today to talk a little bit about data centers and where we are with a lawsuit that has been filed against the Goochland County officials. So some of you may not know us, and let me just take a moment to quickly do some introductions. I'm Susan Willis. I'm a resident in Reader's Branch, and joining me today is John Gessner, who's also a Reader's Branch resident. And additionally, John is a retired land use lawyer from Maryland that is now with us in Reader's Branch. Together, John and I, along with Cynthia Haas, are the three that are spearheading the effort that has resulted in a lawsuit being filed against Goochland County for the passing of their Technology Overlay District, or TOD, and that was done on December the 4th. The actual passing of the TOD by the Board of Supervisors was done on November the 6th. Our goal today really is to talk to you about the status of the lawsuit, and also to address some of your questions that we've heard frequently and maybe even a few misconceptions. So with that, let's get started. So John, let's start with having you just give us an update on where things stand with the lawsuit and what we can expect next.
Well, we're in the process of trying to serve the county government. And by serving, I mean formally delivering a copy of the complaint in the hands of the county's representative, because the county is the defendant in this case. What happens is a summons is issued by the clerk's office, the sheriff takes that summons, and along with the suit papers, physically delivers the papers to the county. The sheriff then fills out a form that confirms the delivery of the papers and files that with the court. Once the court receives that filing, then the county has 21 days within which to file some kind of a response to that complaint. And then after the 21-day period expires, depending upon the response that they have filed, we move forward.
So it sounds like this week coming up is a pretty important one for that serving. And then the county has 21 days. What are the likely alternatives in terms of the county's response that we might think could happen, and the impact of those on the efforts that are going to be asked of us?
Well, I think the county has two basic choices here. One, they can surrender. They can say, look, the complaint points out that we broke the law, whether intentionally or not, and we're going to just simply repeal this legislation because it violates the law. If that's the case, the lawsuit has no reason to go forward, and it should be dismissed at the same time the county repeals the legislation. The other option the county has is to fight it and say that we don't care what you say in your complaint. We believe we complied with the law, and we're going to defend this lawsuit. And the county will file an answer or some responsive pleading, as we call it, that sets forth the reason why they think our lawsuit should lose. Our attorney will take a look at that and decide how best to proceed.
Okay. So if the county does decide to pursue this and defend itself, and then we are going to be taking certain actions, is it an all or nothing? I mean, do we have the option in filing and then starting this lawsuit to decide not to go forward with some parts of it?
Yes, we can decide to dismiss any or all of the lawsuit. At whatever point we deem appropriate, we can dismiss various counts. So we maintain that flexibility and have the option to decide how we proceed.
Okay, good to know. So there have been a few other questions that have come up, and we've thought this is a great opportunity to address some of those. One of those questions that we hear frequently is, what does success look like? If all this goes well and our lawsuit is what we call successful, in terms of outcomes and what we can expect from that, if TOD is struck down, what would you say to that?
Well, keep in mind, this lawsuit is only one aspect of the fight against data centers. We can only fight the lawsuit as set forth in the complaint. So we're trying to get the law overturned, and that's the entire law. So success for us means either the county dismisses its case, because they agree with us that the lawsuit is going to succeed, and they can go ahead and repeal the legislation and reenact it, or we can have a court decide that the legislation with the TOD is illegal, and set it aside. That's how success is going to be defined in this lawsuit, because the lawsuit only deals with the legal issues that I've described.
Okay, that's a good reminder that this is just one piece, but a very important piece, because I know as a citizen, if you tell me something's illegal, I would want my county officials to be within the letter of the law. So thanks for that reminder. So let's move on to a few of the other questions that have come up, because we have had several. Another question that we frequently hear is whether or not things can move forward in terms of the land being sold, the developers building, while this lawsuit is in process.
Okay, in theory, a developer for a data center could file an application tomorrow and proceed under the law, which has not yet been found to be illegal. However, doing so is a huge risk because it's such an uncertain situation. I can't imagine a sophisticated developer wanting to take the risk to go forward with a project when it doesn't even know which law applies. So I think it's extremely unlikely that somebody's going to move forward with a case while this legislation is pending. The only way to stop that and prevent that would be to obtain an injunction from the court, preventing anybody from filing a case until the lawsuit is completed. However, that's very expensive. They're very difficult to obtain. So I don't think that the group of us who are behind this lawsuit are going to ask for that injunction. Okay,
so it sounds like developers we ought to think of them as being a little bit leery while this is going on, which gives us a chance to then think about what's going to happen with the case and what we might want to do.
Exactly.
Another concern that we've heard about is success happens, TOD is struck down. What does that mean in terms of no longer having those limited protections that the TOD claims to provide for us as citizens? How would you respond to that, John?
Well, in the lawsuit, we complain and maintain that certain specific protections, restrictions that the county put in the legislation are illegal. The county never had the right to give those to us in the first place, and they're effectively null and void. So we're not really giving up something that was of value because the county never had the right to do it anyway. However, assuming that for some reason the restrictions stay in place, then you have to ask yourself, what would a developer do? Would a developer want to go ahead and agree to illegal conditions that restrict its right to develop the property? I think the answer has got to be no. So my conclusion is that the restrictions that we filed the complaint on and claimed to be illegal in the complaint, not all of them, but the ones in the complaint, they're going to disappear one way or the other. Either the county's going to, and the courts are going to take care of it, or the developers are going to take care of it.
So who would have delegated that right to the county?
Well, the state law requires that the zoning powers that the counties have to be within certain limits. And we maintain, our attorney, Philip Streller, who's excellent, by the way, he says that they have violated the law and exceeded their authority. And if we're right, and I think we are, then we will win on that issue.
Thank you. It's good to hear. So let's talk a little bit about that fundraising issue, because it's come up quite a bit. And there are some concerns that this is indeed a long case and therefore a costly case. What's going to happen in terms of needed money along the way? And if we don't have that money, I know right now we're looking at a certain milestone goal of $75,000. Can you talk more about that and then the bigger picture around fundraising?
Sure. It's impossible, unfortunately, to know today how much the lawsuit is going to cost. As I said before, we don't know if the county is going to dismiss it or dismiss their defense and go ahead and allow the law to be revoked and repealed, or if they're going to fight it. So if they're going to fight it, that could cost a lot more. But you just don't know until you know what their specific arguments are going to be and their trial tactics, exactly how that's going to take place. So at various intervals, as events take place, we will have to constantly reevaluate the status of the lawsuit, what we think it's going to take, and how much it's going to cost. So once the answer is filed by the county, for example, and we know that they're either going to fight it or they aren't, and they're going to go ahead and repeal the legislation, we'll know then how much more we need. But it'll also depend on the trial date and what pretrial motions, et cetera, might be filed for the county. So we just can't predict it, but the best thing we can do to prepare ourselves is to have a good amount of money in the bank, so to speak, so that if we need it on a short-term basis, we've got it.
And are we doing pretty well with that?
Yes, the fundraising has been going very well. As a matter of fact, our attorney agreed to go ahead and serve the defendants based on how comfortable he feels with the amount of money that we've raised so far, even though we haven't yet reached that $75,000 figure.
Okay. I know this isn't going to happen, but what if we run out of money? Is Philip okay with that, or how does that work?
No, as a retired lawyer, I can tell you, lawyers like to get paid. And if we can't pay Philip, he's going to stop working. And I have absolutely no problem with that. I'm sure nobody does. And without an attorney, this case cannot go forward. So right now, by filing the case within the 30-day time period of the board making this decision on November the 6th, we've preserved our rights. We have the opportunity to protect our county and protect ourselves. If we run out of money and can't afford our lawyer, that opportunity disappears, as does our case.
Boy, I guess you could say no money, no Philip, no case.
That's exactly right. It's that simple.
Pretty simple. Yeah. Thank you. So let's close with some thoughts from you as a retired land use lawyer in Maryland. And what do you think is the likelihood of this case being successful, this lawsuit?
I am very optimistic about the case. I did this for a long time. The arguments that Philip Strother has made, I think, are very strong. Some of them are a slam dunk. For example, the county clearly didn't follow its own rules in proposing amendments the night before it voted. And the other arguments, I think, are equally strong. I would be surprised if we didn't prevail in court on this lawsuit.
That's good news to hear. So donations, let's end on that note, although I love what you just said. I could stop it right here, but we do want to let people know, and I think we're going to provide some information, is that right, on how to make donations, and if they need to contact any of us, who to reach out to.
That's correct. Donate. We need the money. That's the best insurance policy you can buy for your property to make sure that we protect ourselves from the data centers.
That's a great reminder. Property value weighs in on this.
And quality of life as well.
Quality of life. We certainly know that.
It's an investment you can't afford not to make.
Thanks, John. We will end on that. And I appreciate your time today. I hope everyone got a lot out of this session.
Okay.
Thanks.
You're very welcome.